how are you presently employed?
I work for the Federal Bureau of Investigation.
And what is your job with the Federal Bureau of Investigation?
I'm a physical scientist forensic examiner in the latent print operations unit.
And how long have you been employed in that capacity in that unit?
For 4.5 years.
And what what is your education that led you to that job?
I have a Master's of Science degree in Pharmacy and Pharmaceutical Sciences, the concentration in Forensic Drug Chemistry from the University of Florida, located in Gainesville, Florida. I have a Bachelor's of Science degree in Microbiology with a minor in Chemistry from the University of Rhode Island, located in Kingston, Rhode Island.
And have you had any training within the FBI that led you to your present position?
Yes. I successfully completed an approximate 18-month training program in the latent print unit at the FBI. During that training program, I learned about the biology of friction-rich skin, how to record known prints, how to properly handle and process evidence for the detection of latent prints, and how to actually conduct comparisons. During my training, I processed hundreds of items of evidence and completed approximately 75,000 comparisons. Towards the end of my training, I worked cases under the supervision of a certified examiner, and upon completion of the training program, I successfully completed the FBI's certification exam in the area of friction ridge analysis.
And when did you become, is there a point when you become an examiner that's permitted to do examinations after your training is over?
After I was certified in July of 2008. Following that period, I was on what we call a probationary period for 6 months. This is when a supervisor looks over your work for a period of time, and after that 6-month period is completed, you are able to work cases without having someone check over your work completely. However, our work still goes through a technical and administrative review process.
Now, is the period of what you call probation, is that standard for all new examiners?
Yes, it is.
So it's not like a punishment for anything?
No.
Okay. Now, I'll direct your attention to December of 2008 and ask if you had occasion to examine some evidence submitted in the investigation of the death of one Caylee Marie Anthony.
Yes, I did.
And was that in the form of some duct tape that was reported to you as having been obtained from the remains?
Yes, it was 3 pieces of duct tape.
All right. Let me show you what's been marked as State's Exhibit for identification KN. May I approach the witness?
You may.
Let me show you State's Exhibit KN for identification and ask if you recognize it.
Yes, I do, and I know I do because my initials appear on the white tag on the outer packaging of the bag.
Right. And is this the bag that you were sent which contained the duct tape?
Yes, and again, I know this because my initials appear on one of the seals of me indicating that I sealed this package.
Thank you. This time, Your Honor, I move into evidence State's Exhibit KN for identification.
What says the defense?
The package, Your Honor.
You may. We received an evidence that states numbered
302.
Now, Ms. Fontaine, when you got this item of evidence, did you have to go any efforts to separate the 3 pieces, or were they already separated?
May I refer to my case notes, please?
You may.
Your Honor, may I refer to my notes?
Yes, ma'am.
Thank you. Upon initial receipt of the evidence, how I receive evidence is an item of evidence receives a Q if it is a questioned item. Other items receive K if it is a known item. In this case, those items, those 3 pieces of duct tape were received to me as Q items, and I refer to them as Q62, Q63, and Q64. Q62, upon initial receipt, was a separate piece of tape, and Q63 and Q64 were initially received on top of each other or stuck together.
Did you have to use any efforts to separate them?
I actually did not separate those 2 pieces of tape that were stacked or stuck together. An examiner in the trace evidence unit did this.
All right. Did you, however, later examine them separately?
I examined them stuck together and separately.
Now, can you describe first Q62 as far as its size and its condition, according to, and if you need to refer to your notes, refresh your recollection, go right ahead.
My notes indicate that Q62, Q63, and Q64 were each approximately 6 to 8 inches in length.
All right. And what was their condition as far as, did you note that they are weathered or that they look new, old, any of those observations?
Okay. I have indicated in my notes that the glue was almost gone and that the duct tape was no longer sticky. And the glue had migrated along with the strings or fibers within the duct tape towards one end and had formed a glob of glue and fibers. Basically, the duct tape was no longer a sticky type tape, but rather the plastic with the glue and strings hanging on to the rest of the plastic.
So had some of the strings separated from the plastic or vinyl part of the tape?
That's correct.
Now, did you subject Q62, Q63, and Q64 to examination in an effort to find possible latent fingerprints?
Yes, I did.
Now, were you given a history of where this tape was found, under what conditions?
I was told that the tape was found on the remains and that it was found in an area that was periodically subjected to flooding.
Exception?
She is an expert, Your Honor, and she's permitted to base her opinion on hearsay, and I'm going to ask her opinion in a moment.
Overruled?
All right. Now, based upon the history you were given, did you have an expectation of any probability of finding latent fingerprints?
Objection, that's called speculation.
Overruled?
Go ahead.
Evidence that is subjected to environmental factors, I would not expect latent prints to be found. This is because latent prints are very fragile and are comprised of oil, sweat, or similar substances. However, I do not go into an examination process if I have the thought that I will not expect to see latent prints. It does not change my examination of that item of evidence. My process and my examination, regardless of what I think the end outcome will be, does not change.
Now, when examining Q62, were you able to find any latent fingerprints?
No, I was not.
In examining Q63, were you able to find any latent fingerprints?
No, I was not.
And in examining Q64, were you able to find any latent fingerprints?
No, I was not.
During your examination of these exhibits, did you note in your notes something that you did see?
Yes, I did.
We would renew our previous motions and objections.
Renewed objections will be overruled.
And on which exhibit did you see this item we're going to talk about?
Let me refer to my notes, please.
Please do.
It was on Q63.
And what did you see?
During my examination of Q63, an outline of a heart appeared in one of the corners on the edge of that piece of duct tape.
Now, what process were you using when you noticed this artifact?
I was using an alternate light source called RUVIS, which is an acronym that stands for Reflective Ultraviolet Imaging System. This process is utilized after superglue, and it helps visualize a three-dimensional object or an object that has different depths or dirt or not a flat surface. It also helps visualize reflective surfaces. It helps minimize the glare and any bumps or distortion that flat surface may have. This alternate light source helps make that a flat, non-reflective image.
Is that process used normally to raise otherwise invisible fingerprints?
It helps eliminate any background that the object that you're processing for the development of latent prints may have in interfering with properly visualizing latent prints.
Now, can you give us any further description of what this shape looked like? About how big was it?
It was approximately the size of a dime. And the best way to illustrate what I saw was if you were to wear a Band-Aid for an extended period of time and eventually remove that Band-Aid, you have that glue or debris surrounding the outer edges of that Band-Aid. The outline of the heart resembled that glue or debris that if you had been wearing a Band-Aid for an extended period of time. However, rather than in the shape of a Band-Aid, it was in the shape of a heart.
Now, upon seeing that, did you believe it to be of any special significance in the case at the time you saw it?
At the time, no.
Did you note it in your file?
I noted it in my file, and I notified the appropriate people involved in the case.
Did you also call over a supervisor to view it as well?
Yes, the supervisor was with me that evening and also observed the heart shape on the duct tape as well.
Sustain. Motion to strike the last answer will be granted.
Thank you. Without saying what she may have said, did she come over and view it in your presence?
Yes, she did.
All right. Now, did you photograph it?
No, I did not.
Why not?
My job is to process evidence and examine evidence for the detection of latent prints, to then take those latent prints and compare them to known prints, other latent prints, or to search them in the FBI's fingerprint database. When I observe something that is unexpected, I note it and continue on with my examination. The FBI does not require photographing of unexpected items to be done. In this case, when I observed the unexpected item, I continued on with my examination. And upon completion of processing and examining the duct tape, I did attempt to photograph the heart. However, at that point in time, it was no longer visible on the object.
Now, what had you done to the object between when you first saw it and when you... Let me stop. Did you later come back and photograph it based upon discussions with law enforcement that it might actually be something important?
No, I did.
Overall.
Go ahead.
No, I did not.
Right. Why did you go back and attempt to photograph it later?
I had completed my examination and felt that at that point it was appropriate to attempt a photograph.
What processes had you used on the tape in order to try and lift prints between seeing it and then not being able to find it again?
I conducted an alternate dye stain known as RAM. Each of those letters stand for a different dye stain. RAM is a strong solvent that colors superglue so that when I can visualize white superglue prints on white objects or objects that have a reflective property to them underneath an alternate light source such as a laser. This allows... I'm sorry. Sure. RAM is a dye stain that dye stains white superglue prints. This dye stain enables a fingerprint examiner to look at white fingerprints on white objects and also on reflective objects by utilizing alternate light sources such as a laser. The print, rather than being white underneath the alternate light source, will then glow an orange type color. I used that examination as well as black powder, which is the typical black powder as you see on CSI with the brush. And I also used alternate black powder, which is the same black powder mixed with a solution to process anything that is sticky or glue-like on the items of evidence.
But when you went back to try and photograph the whatever it was, you couldn't find it anymore.
That is correct.
Now, do you know what that artifact was?
Other than stating that it was in the shape of a heart, approximately the size of a dime, I cannot go further.
And do you have any idea how it got there, or when it got there, who put it there, or why?
No, I do not.
May it please the court. Good morning, Ms. Fontaine.
Good morning.
The items that you were given to inspect, you were given them second, correct? Q62 to Q64?
What do you mean by second?
Who was the first person from the FBI to receive these items?
All items of evidence are received in our evidence control unit as a standard policy and protocol within our unit, and they conduct an inventory. After the 3 pieces of duct tape went to our evidence control unit, it did, according to my chain of custody, prior to me going to the trace evidence unit. However, how the evidence went from the evidence control unit to the trace unit is not detailed in my case records.
Okay. I apologize. I'm not sure I understood that.
That's okay.
Okay. First, it's collected at the scene, right?
Correct.
And then Orange County Sheriff's Office has it, right?
I do not know the travel path of these 3 pieces of tape other than once they were received in the FBI laboratory.
Now, it goes to Tampa first, does it not?
Again, I don't know the path until it enters into the laboratory.
Okay. And then it got to the evidence control unit.
That's correct.
Okay. These are the people who kind of distribute which evidence goes to where, correct?
That is correct. They also conduct an inventory of evidence received.
They're the ones inventorying everything and saying, okay, this is going to go here first and this here second, and so on and so forth.
That is correct.
Okay. So evidence control unit got it, right?
Yes.
Then it was taken to your division, correct?
Prior to me receiving it, it was received in the trace evidence unit. That is where I received the 3 pieces of duct tape from.
And the trace evidence unit searches it for trace evidence, correct?
Upon their initial receipt of the items of evidence, they contacted myself so that I can conduct a visual examination on the items. This is typically done because latent prints are generally latent print unit generally receives evidence last. So we work closely with other units so that if there's any fingerprints that may be seen visually, we can photographically capture them then rather than waiting for it to be received in our unit at a later point in time.
Okay, so now we're at trace evidence unit.
Correct.
And they call you over while they are conducting their examination.
That's correct.
And they're searching for hair,
I assume so, yes.
fibers,
Again, I assume so.
anything that would assist the jury in determining what's going on with this piece of evidence, correct?
And again, yes, I assume so.
All right. Now, then it goes to you.
Yes.
Okay. And the very first thing you did you start with Q62?
I initially started, I don't exactly remember if I started with 1, 2, or 3. Since they were 2 stacked together and 1 was separate, I'm sure I started with the one that was separate first, which was Q62.
Okay. So you're the second division, so to speak, to get this, or the second person to get this type of evidence, right?
Yes.
Okay. Now, when you got Q62, you then began, what was the first process you did for fingerprinting?
Initially, when I received the 3 pieces of duct tape after being notified by the trace evidence unit, I conducted a visual examination. This is very basic by holding the items of evidence and maybe rotating or tilting it slightly for different lighting to see if any latent prints are visible without any chemicals or forensic processes.
And this helps you in your normal course. This is something you're trained to do because this often allows you to pick up latent prints, correct?
It is always the first step in our examination process, yes.
Okay. What's the second step?
The second step is a laser, which is just like you see on TV or the laser pointers. It's very similar to that. It's at a wavelength that allows us to visualize or potentially visualize latent prints.
And the wavelength of the laser is what allows you to see any types of items that may or may not be on the tape, correct?
Yes, a certain percentage of the population has fingerprints that naturally fluoresce, given the lotions that they use on a daily basis or the items that they handle. So we look at second look at evidence using a laser to see if there's any naturally fluorescing fingerprints.
Okay, and then what's the third step you take?
This third step is UV or ultraviolet. It's very similar to the laser. It's just at a different frequency, again, to visualize any potentially naturally occurring fluorescing fingerprints.
And these different frequencies are what allows you to sometimes pick up on latents that the previous alternating light sources do not, correct?
That is correct. Our processes are in a sequence that allows us to optimize the visualization of latent prints.
And then what is step 4?
In this case, step 4, the items of evidence actually went back to the trace evidence unit for them to do a full collection of their evidence that they needed to do.
And then at that point, that's when they may take out any fibers or anything that's there.
That is correct.
Okay. Then it came back to you, did it not?
That is correct.
And what happened when you got it on that occasion?
When I got all 3 pieces of tape back the second time, I redid the first 3 steps that I just told you about: visual examination, laser examination, and ultraviolet light examination. This was done because Q63 and Q64 were once stacked on top of each other, and now they no longer were.
And that was disconnected by the trace evidence unit.
Yes,
Okay. A completely different person.
correct.
Okay. So now we're at, I believe, step 6.
Sure. Step 6 is super glue. And I'm sure if you've seen CSI, you see them stick the tube in the car and the white fumes super glue the interior of the car. It's the same thing, just on a different scale, and all 3 pieces of tape were super glued.
Okay. And how does that assist you in being able to lift fingerprints?
Super glue is attracted to moisture. So when the evidence is super glued it is super glued in a humidity chamber, which means we add moisture to the air within that chamber. That moisture is attracted to any latent prints that may be on that item of evidence. That moisture then attracts the super glue to that moisture and eventually allows the super glue to harden, making almost like a coating or a shell over that latent print.
Okay. And then what did you do after that?
The next after super glue was
I'm sorry, I didn't mean to stop you. That's step 7, right?
Yes.
Okay, go ahead.
The next step after super glue is RUVIS, that reflective ultraviolet imaging system that I spoke of previously.
Now, the RUVIS system is fairly advanced, is it not?
I don't know what you mean by advanced.
Let me rephrase that. For the layperson, describe to us what RUVIS is.
Sure. The RUVIS system is an ultraviolet light that is shown down through a filter and a camera onto the object. This camera then presents an image onto a computer screen. It's very similar to the one next to me, and it allows you to visualize the object. So you're actually not looking at the object, but you're looking at the monitor while you visualize what the RUVIS is doing. And the RUVIS, as I spoke of earlier, shines down onto the object, helping eliminate any reflective properties that the item may have, and also helps take away the 3D effect that may be on that item as a result of debris or dirt or crinkles in the actual material.
And the filter is what allows for that to occur, correct?
I'm not sure how it works exactly. I know when all put together, that's how it works.
Okay. And that comes up on a screen. It's also blown up for you, somewhat. I don't want to use like a microscope, but basically enlarges it for you, does it not?
Yes, since the imaging system, the image is portrayed on a monitor very similar to this size, the object that is visualized through the imaging system is enlarged to fit onto the monitor screen.
Okay. And that is step 8.
I guess, yes.
Okay. Anything else after that?
After the RUVIS, the next step is the RAM, where's that alternate dye stain that I spoke about, and the final process is black powder.
Let me stop you there. Explain RAM for us.
Sure. RAM is a dye stain that is used on top of super glue. The super glue I use is the same super glue that you guys all have at your house. It dries white, clear type color. So sometimes it is hard to actually visualize that cloudy white type print that may be on an object. So we utilize a dye stain, and at the FBI, we mostly utilize RAM. This dye stain stains that super glue rather than a white color. It gives it fluorescent properties to it so that I can utilize the ultraviolet light and a laser to help visualize that latent print, and now it will glow orange.
Okay. And then after the RAM, that's after step 9, what happens on step 10?
In this case, step 10 for me was alternate black powder. This is regular black powder mixed with a solution, which is then painted onto any glue or sticky substance that may be on the item. Typically, step 9 or alternate black powder is utilized only when there is a glue type substance. It is not a normal procedure on items of this type.
And that was your final test, correct?
No, I have one more.
Oh, okay.
The final step was black powder. This is the traditional black powder that you've seen on where they dust and they powder with a brush on the counters. This is just black powder that is applied.
And why is that used? I'm sorry if you can throw that in there
That's
as
fine.
well.
Latent prints, because they are comprised of oil, sweat, or similar substances, when you touch an object, you leave behind a fragmentary reproduction of your friction ridge arrangement that leaves behind oil or sweat. So when you powder, and you all seen that when they do on CSI, they take the brush and they... I'm sorry. When you powder and you move the brush between your fingers over the latent print that is comprised of oil, sweat, or similar substances, that powder is attracted to and adheres to, in a sense, to the moisture of that latent print.
And 11 is where we conclude.
I've lost count, so I guess yes.
Okay. Now, after you've done this, you of course do this on both sides, correct?
The alternate black powder is only applied to the glue type area, so that was a specified area that was applied to.
Okay. But all the other steps were on both sides of the tape.
That is correct.
And that's because someone could touch both sides of the tape with either finger, correct?
Yes, I don't go into processing an item of evidence with any expectations. So all of our processes and all of our examinations is conducted on the entirety of the object.
Now that's how you went through Q62.
And Q63 and Q64.
About to go there. So Ms. Fontaine, then you went to Q63, and don't worry, I won't make you repeat all that stuff again.
Okay.
But you started on Q63. Now, I recall in your testimony, you were very specific that you didn't want to say any more than what you saw, right?
That is correct.
And you can't speculate any further than that, correct?
That is correct.
Now, Q63, when you saw this small item, it was just something visual, correct?
It was something that I visualized in the RUVIS system, or that reflective ultraviolet imaging system.
And that was step 7.
I don't remember.
Okay. And then after you had completed step 11, you came back and it was no longer there.
Upon completion of processing the item of evidence, it was no longer visible, yes.
Okay. So, however, when you saw that item, this was after you had gotten it, or after you had gotten it back from the trace evidence unit for the second time, correct?
All of my processes were done after the examination of the trace evidence unit.
Okay, so it goes, so you have something that is received at the FBI, it goes to trace evidence, you're there, you do a visual there, then it comes to you, correct?
Correct.
Then it goes back to trace evidence unit, correct?
Sustain.
And then you get it back and that's where you started step 1 through 11, correct?
I restarted steps 1, 2, and 3, and then introduced 4 through the end.
Okay. And after you received something, you actually did a report in this case, correct?
Yes.
Okay. And in the report, you indicate that Q62 through Q64 had no fingerprints whatsoever.
That is correct.
And this is including your thorough examination of each piece backwards and forwards, correct?
Yes.
And you follow, or you're aware of this item of evidence because it's an item of evidence that you may testify in this case, correct?
I'm not sure I understand your question.
What I mean is, you're aware that the item of evidence, after you're finished with it, goes back to evidence control and then probably to another division.
That is correct.
Okay. And you're aware that the item was later contaminated by another member, weren't?
Hearsay. May we approach?
You may. Objection sustained. You may continue.
Ms. Fontaine, after you conclude your examination, you just fill out a report of what you know and what you don't know, correct?
I fill out a report with what my conclusions are.
Okay. And your conclusions when inspecting Q62, Q63, and Q64 was after doing a complete and total workup using multiple different techniques, you were not able to find any fingerprints on either piece of duct tape.
That is correct.
I have no further questions.
Redirect.
You said that Q63 and Q64 were stacked.
That is correct.
Which was on top?
According to my,
Overruled.
Q63 was on top of Q64.
No further questions.
May the witness be excused.
Subject to recall.
Yes.
Okay. Thank you, ma'am.
Thank you.
Your Honor, as we'd indicated earlier, this, our only other witnesses we have, the next witnesses available will not be here till tomorrow morning. So we have no further witnesses to present this afternoon or tomorrow morning. We apologize for the inconvenience, but the schedules couldn't be adjusted.
The witnesses for tomorrow will be here tomorrow when?
They will, I believe they arrive at 11, so they should be here and ready to testify at 1:30 in the court's normal afternoon schedule.
Okay.
Thank you.
All right, ladies and gentlemen of the jury, let me give you an update as far as I know what's going on, and that is subject to change. Based upon what I know and what the lawyers think may happen, is that the state may wrap up their presentation tomorrow afternoon or sometime Wednesday. Just depends, but they should conclude their presentation tomorrow or sometime by noon on Wednesday. We had anticipated the defense starting on Thursday, but they are trying to accelerate that process to start on Wednesday, if possible, but we will know because you got to shift some travel plans and run through those logistics with other witnesses. So far, we are ahead of schedule. Depending on the length of the defense's presentation, and we will have some flavor of that by Saturday, we should have an idea that maybe the following week, and I use the word maybe, and we will recalculate that after we look at it. Probably I don't want to make a guesstimate on that until Saturday, but I kind of think that maybe by the end of next week, we will conclude all of the evidence in this case and get you deliberating, hopefully, the 25th or the 27th. But that is all subject to change, so don't hold me exactly to that. That is my best. Yeah. Okay, ladies and gentlemen of the jury, we're going to recess.
And how long have you been employed by the FBI?
For 23 years.
What work did you do while with the FBI laboratory before your current position?
For 6.5 years, I was a research scientist, and in that position, I researched and developed new forensic DNA typing techniques for the FBI laboratory and for other laboratories. Then for 5 years, I was a quality assurance specialist in the FBI laboratory, and I developed quality assurance procedures and practices for use by our laboratory. And then following that, for 9 years, I was a forensic mitochondrial DNA examiner.
What is your educational background that led you to your positions with the FBI?
I have a bachelor's degree in biology from the University of Virginia and a PhD in human molecular genetics from Johns Hopkins University.
Have you taught any classes in forensic DNA analysis?
Yes, I have. Over my career with the FBI, I've taught numerous classes, mostly at the graduate school level, to personnel from crime labs from around the country as well as other labs in the world.
And what specialized training, or have you received any additional training with the FBI laboratory since the PhD and the master's you told us about?
Yes, specifically for my position as a forensic mitochondrial DNA examiner, I was in our training program for over a year, and that training program consisted of formalized lectures, an independent study, as well as lab work, and at the culmination of that was being subjected to numerous examinations which qualified me to be a forensic mitochondrial DNA examiner.
Have you ever testified as an expert in that area in the past?
Yes, I have.
On approximately how many occasions?
This is my 20th time.
And in how many different, all federal jurisdictions, all state, or a mix?
A mix, mostly state and local jurisdictions.
This time, Your Honor, I would submit the witness as an expert in the area of forensic mitochondrial DNA analysis.
No objections, Your Honor.
The witness will be accepted as expert witness in the area tendered. You may proceed.
Thank you. Pardon me. Would you tell us, if you would, what type or types of DNA testing are done by the FBI laboratory?
The FBI laboratory conducts nuclear DNA testing and mitochondrial DNA testing. Nuclear DNA is inherited from both of our parents, from our mother and our father, and nuclear DNA testing then gives us the ability to potentially identify a person as a source of an item of evidence to the exclusion of any other individual. Mitochondrial DNA, on the other hand, is inherited only from our mothers. So we share our mitochondrial DNA type with our mothers, with any siblings we have that share the same mother, and also by chance we share our mitochondrial DNA type with other non-related people. So therefore, mitochondrial DNA testing does not give us the ability to identify a person to the exclusion of anybody else.
How is a mitochondrial DNA examination conducted?
There are several steps that make up a mitochondrial DNA examination. First, the DNA is extracted or isolated from an item of evidence. That DNA is then subjected to a process that we call PCR, which copies that DNA or amplifies it, which then gives us enough DNA to take further along in the following steps of the test. Once we amplify that DNA, we then type it through a process called DNA sequencing. And that DNA sequencing allows us to look at the individual building blocks of a portion of our mitochondrial DNA. That by looking at those building blocks, we can establish or determine a mitochondrial DNA type. And in a forensic examination, we'll typically compare mitochondrial DNA types from different items of evidence, both items of evidence of unknown origin and items of evidence which may be known reference samples from individuals involved in a case. And finally, those mitochondrial DNA types can be subjected to a search in a mitochondrial DNA database.
And what are the possible outcomes of a mitochondrial DNA analysis?
If a mitochondrial DNA type from an item of evidence from a crime scene is different from a mitochondrial DNA type from an individual from a known reference source, that item of evidence can be excluded as originating from the source of that known reference sample. On the other hand, if two mitochondrial DNA types are the same, the source of the reference sample can be included as a source of that item of evidence.
If an individual cannot be excluded and is a possible source, what is the significance of that?
If an individual cannot be excluded as a source of a particular item of evidence, we then calculate an estimate of how common or how rare that mitochondrial type is in the general population. And that estimate is based on the results of our database search.
Why would a particular piece of evidence be why would a mitochondrial test be used at a particular piece of evidence as opposed to a nuclear DNA test?
We use mitochondrial DNA testing in or on items of evidence which we would expect would not give us enough nuclear DNA to conduct that kind of test. Typically, that kind of evidence may be a shed hair or skeletal remains. Those items may not have enough nuclear DNA. Therefore, mitochondrial DNA typing gives us some DNA evidence, some DNA type, which then is a powerful tool for excluding a person as a source of an item of evidence.
In July of 2008, was some evidence submitted to you for possible examination in reference to a victim by the name of Caylee Marie Anthony?
Yes, it was.
Did those, pardon me, did those exhibits include a portion of a hair designated by your laboratory as Q12 that was identified by trace evidence examiner?
Yes, the designation of that hair was actually Q12.1.
The portion that you got was 12.1.
That's correct.
All right. Well, you also submitted some purported buccal swabs from someone named Caylee Anthony.
Yes, that item was identified in our laboratory as item K1.
Madam Clerk, could I have items for identification IU and IV? May I approach the witness?
You may.
Let me show you what's been marked for identification as IU and IV and ask if you recognize those as containing the buccal swabs purported to be from Caylee Anthony that you examined.
May I open this package?
You may.
Yes, this item is identified as K1, identified as a buccal swab from Caylee Anthony.
Right. And that was in reference to State's Exhibit IV. If you do the same examination of IU.
Yes, this is another sample of item K1, identified again as a buccal swab from Caylee Anthony.
And is that one of the items that you looked at in your examination?
Yes, it was. I can identify that by the initials of the staff in the laboratory.
Thank you.
Could I get some water, please?
Oh, yes.
Thank you.
Mr. George, would you mind getting the witness a bottle of water? I think we have one on the table there.
Thank you. Thank you.
This time, Your Honor, State would move into evidence State's Exhibit IV and IU.
What says the defense?
No objections, Your Honor.
You received an evidence the state's numbered.
State Exhibit IV will become State Exhibit number 303. IU will become State Exhibit number 304.
All right. Did you do a mitochondrial DNA test on State's Exhibit, on your Q12.1, which is a portion of the hair purported to be from the trunk liner of a vehicle?
Yes, I did.
And were you able to get a mitochondrial DNA? Would it be called a profile?
A profile or a type, both are appropriate.
Okay.
Yes, I did.
Did you also obtain a mitochondrial DNA profile from the exhibits I just showed you?
Yes, I did.
Based upon those two profiles, can you come to any conclusions?
Yes, I can.
What would those conclusions be?
The mitochondrial types from the Q12.1 hair and the K1 buccal sample identified as coming from Caylee Anthony are the same. Therefore, neither Caylee Anthony nor Caylee Anthony can be excluded as the source of that Q12.1 hair. Further, I would not expect to see that mitochondrial DNA type in more than 0.26 of the African American population, nor in more than 1.85% of the Caucasian population, nor in more than 3.9% of the Hispanic population.
Now, when you indicate that that result cannot exclude either Casey Anthony or Caylee Anthony, your assumption is, your understanding is Caylee Anthony is the daughter of Casey Anthony.
Yes, that is how it was identified to me.
Would that result, also not exclude Casey Anthony's mother?
That's correct.
Would it also include, and I'll just use that word include because it's easier for me to say, Casey Anthony's brother from the same mother?
That's correct.
And it would also include Casey Anthony's maternal grandmother?
It would.
All right. And any maternal uncles?
It would as well.
All right. Now, turning now to December of 2008, did you receive an additional sample for mitochondrial DNA examination?
Yes, I did.
And was this designated by your laboratory as Q59.1?
Yes, it was.
And was this a portion of an exhibit identified as Q59, identified as a hair mass?
Yes, that's correct.
And did you subject portions of that to the same mitochondrial DNA examination as the 12.1 hair?
Yes.
And what were the results?
The mitochondrial DNA type from the Q59.1 hair is identified as coming from the Q59 hair mass is the same as the mitochondrial DNA type of the K1 buccal sample identified as coming from Casey Anthony. Therefore, Caylee Anthony cannot be excluded as cannot be excluded as the source of the Q59.1 hairs from the hair mass. I would not expect to see that mitochondrial DNA type in more than 0.26% of the African American population, nor in more than 1.85% of the Caucasian population, nor in more than 0.39% of the Hispanic population.
So therefore, based on your examinations, the hair from the trunk, Q12, and the hair mass, Q59, are a mitochondrial match. Is that correct?
That is correct.
And they would match either Caylee Anthony, Casey Anthony, or anyone in the maternal line.
Yes.
Now, would then you look to other disciplines to further narrow down the possible contributors beyond that?
Yes, mitochondrial DNA alone cannot make those distinctions.
But other disciplines such as trace analysis might be able to further limit the possible contributors.
That is possible, yes.
No further questions, Your Honor.
Cross-examination.
May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Ms. Tyson.
Good afternoon.
Now, you testified that you were, or the quality control officer for DNA 2 division?
And now I'm the quality manager of the FBI laboratory.
Okay, so that's the entire laboratory?
Yes, it is.
Okay. And could you explain to the ladies and gentlemen of the jury exactly what that means?
What that means is that I oversee a group called our Quality Assurance Group, and that group is responsible for putting into practice numerous policies and procedures which ensure the quality of our casework. And we also evaluate proficiency tests, conduct audits of our laboratory, ensure that we meet all the standards of our accreditation.
And just to kind of break that down a little bit more, the policies and procedures, they're often called protocols, are they not?
We do use those terms slightly differently, but in general, yes, that's correct.
Okay. And what you do basically at times is you develop the rules of how each item is processed and how each item of evidence moves forward throughout the laboratories, correct?
In our unit, we do that to a general degree, and then each individual discipline or caseworking unit has further procedures which specify how items of evidence are moved through and processed through their individual units.
And what that does, and part of that, even for your area, of mitochondrial DNA, at least when you worked in that division, there would be like a checklist of things that you have to do and check off as you process that item of evidence, correct?
We don't actually use a checklist, but there is a set procedure that is used as cases and evidence are processed.
And as part of quality control, you also have sometimes people checking up on the first examiner's work, correct?
Yes, all of our casework is subjected to, at a minimum, 2 levels of review.
And what's done in addition to that is each person who works in your laboratory also has proficiency tests to make sure their work is up to par, correct?
Each person who handles and processes evidence in a particular forensic science discipline is indeed subject to proficiency tests, yes.
Okay. And the reason that you have all of these steps in place is to prevent contamination, correct?
Objection exceeds the scope of direct.
I believe
Sustain.
that this witness has testified about that area, Judge.
Sustain.
Yes, sir. Now, the laboratory, and part of your job as the quality control officer would be to ensure, as you mentioned, that everything's in compliance with the accreditation of the laboratory, correct?
Objection exceeds the scope of direct, which was,
This is something the witness has testified both under direct, Judge, and cross.
Your Honor,
Sustain.
Now, your job as the quality control officer, of course, is to ensure that the integrity of the evidence is handled in its most efficient manner, is it not?
objection exceeds the scope of direct.
Sustain.
Ma'am, as you testified, the entire maternal line in mitochondrial DNA cannot be excluded as to either piece of evidence that you handled, correct?
In general, that is true, yes.
Okay. And the item of evidence, specifically the Q12.1 item, that there is no indication as to, or you were not given any information as to its history, correct?
That is incorrect. I was presented with information as an examiner in a caseworking unit. I do get the communications that come into our laboratory about the case in general and have those to review during when I'm conducting my casework.
So, okay, so you were informed then that Lee Anthony once owned the Pontiac Sunfire, correct?
I did.
Hearsay.
I think this witness has testified that she was given information to help base her conclusions, Judge.
I don't believe that she indicated that that was the basis of any conclusions she drew.
Sustain.
Do you use this information to assist you in carrying out your work?
No, I do not.
Okay. So it's just gratuitous information that you read because you like to read up on those topics? Or do you find that useful in your work?
Read those. It's not used as a basis for my conclusions.
But it is still used throughout the course of your work, is it not?
I guess
Because you read a file before you actually go on and do the work, do you not?
I certainly do read their letters, yes.
Okay. So in those inclusions, as you read your file, did it include the fact that Lee Anthony once owned the Pontiac Sunfire before Casey Anthony did?
Objection, hearsay.
Sustain.
Were you given any further information about the potential people who could not be excluded, such as Cindy Anthony and her maternal line?
Objection to hearsay because the question is vague.
I don't think the question's vague, Judge.
The
pretty-
question can be answered simply by yes or no. Objection overruled.
Could you please restate the question?
Sure, I understand. Were you given any other information as to the other people who could not be excluded on the maternal line, such as Cindy Anthony and other relatives?
I'm not sure what you mean by information. It may have been in the communications, the names of the parents of Casey Anthony.
Okay. And other relatives as well who couldn't be excluded?
would be, excluded?
That could not be excluded, excuse me. Sorry.
I don't recall specifically the mention of a Lee Anthony in the particular communications that I have.
Okay. No further questions. Thank you, ma'am.
Any redirect?
No, sir.
May the witness be excused.
As far as the state's concerned, yes.
Thank you, ma'am. You may be excused.
Thank you, Your Honor.
You may proceed.
Thank you. Please tell the court and the members of the jury your occupation.
I'm a crime scene investigator with the Orange County Sheriff's Office.
How long have you worked for Orange County?
I've been with Orange County since November 18th of 2003, which is approximately 7.5 years.
Were you working for the Orange County Sheriff's Office as a crime scene investigator back in December of 2008?
Yes, I was.
Right. Did you assist other crime scene investigators in the collection of evidence at the recovery site of Caylee Marie Anthony's remains in December of 2008?
Yes, I did.
Did you also assist other crime scene investigators during the execution of a search warrant on the Anthony home on Hope Spring Drive on December 20th of 2008?
Yes, I did.
If I may show the witness what has been marked as BT for identification? Thank you. Can you see that on your monitor, ma'am?
Yes, I can.
Are you familiar with the locations? I have it on unpublished.
Is it still on? Okay. Go ahead.
Okay. Are you familiar with the locations shown in the photo?
Yes, I am.
Okay. Does this photograph fairly and accurately depict the distance between the two locations, that being the Anthony residence on Hope Spring Drive and the scene where Caylee Anthony's remains were recovered on Suburban Drive?
Yes, it does.
Your Honor, at this point, I would seek to introduce BT for identification into evidence.
No
Says
objections.
the defense.
No objections, Your Honor.
It will be received in evidence as states numbered.
305.
Okay, may I appropriately publish this to the jury at this point?
You may.
All right. Ms. Burrows, we have a notation on there as to the location of the Anthony home. Can you circle the area? The screen is a telestrator. Can you circle the area where the remains were located?
Yes, the approximate area was right there.
May I unpublish?
You may.
Now, you had indicated that you also assisted during the execution of a search warrant on December 20th of 2008. What role did you play during that process?
During this process, I facilitated the location, collection, and documentation of evidence pursuant to a search warrant at the Anthony residence.
All right. If I may, did that include your seeing items before their collection?
Visually seeing the items before I handled them.
Yes.
In some cases, I might see them in their present location, or in some cases, after they had been discovered, they had been brought to me.
All right. Are you familiar with whether or not there were heart stickers located in the bedroom of Casey Anthony during the execution of that search warrant on December 20th of 2008?
Yes, there were.
If I may show the witness QV for identification.
You may.
Do you see QV?
Yes, I do.
Is QV a fair and accurate photograph of an item that was located in Caylee Anthony's bedroom?
Yes, it is.
Your Honor, at this time, I would seek to introduce QV for identification into evidence.
What says the defense? You may. You may approach, along with the court reporter. You may proceed.
Thank you. Investigator Burrows, where was this item located?
This particular item was located inside a yellow type of box, inside a dresser along the north wall of Caylee Anthony's bedroom, just east of the head of the bed.
The box where that was located, did it contain other items?
Yes, it did.
Did the other items include an envelope?
Yes.
When the item was photographed, was the envelope just part of the background of the location where the sticker or the part of the sticker was found?
Yes, it was.
Okay. Is the sticker affixed to the envelope in any fashion?
No, it is not.
Your Honor, at this point, I would seek to introduce QV for identification into evidence.
Just renew our previous motions and objections, Judge.
Noting the defense's previous objections, it would be admitted into evidence over defense objections as states exhibit numbered.
Permission to publish this item to the jury, Your Honor.
You may publish.
And permission to unpublish.
You may.
May I have QW for identification, please? Do you see that item in front of you?
Yes, I do.
Okay. Is this a close-up of the same item that was displayed in 306 in evidence?
Yes, it is.
Does that also accurately depict the condition of the item when it was discovered during the search warrant?
Yes, it does.
Your Honor, at this point, I would seek to introduce QW for identification into evidence.
Same motions and objections.
Noting previous objections, objection would be overruled. It will be received in evidence as states numbered.
If I may approach the witness with what has been marked as QN for identification.
You may.
You would take a look at the packaging on that item and tell me if you recognize it as something that you've had contact with in the past.
Yes, I do.
What do you recognize it to be?
This is the same red and white heart-shaped sticker backing that was shown in the previous pictures.
Was that collected and packaged by you and sealed in that envelope?
Yes, it was.
Your Honor, at this point, I would seek to introduce QN for identification into evidence.
What says the defense?
Same motions and objections, Judge.
Noting previous stated objections, objections will be overruled. They will be received in evidence as states numbered.
308.
If I may have QX for identification. Do you see QX?
Yes, I do.
Right. Are there other stickers in that photograph that were collected and seized by you?
Yes, there are.
Where were those stickers located?
This is a sheet of heart-shaped stickers that appeared to have been cut in half. It was located inside of a black binder in that same cabinet as the previous sticker, which was located along the north wall in Casey Anthony's bedroom.
Does this photograph fairly and accurately depict those stickers that were located in Ms. Anthony's bedroom?
Yes, it does.
Your Honor, at this point, I would seek to introduce QX for identification into evidence.
What says the defense?
Same motions and objections.
Noting the defense's previous stated objections, objections will be overruled. It will be received in evidence. The state's numbered.
Permission to publish, Your Honor.
You may publish.
All right. Can you indicate by circling the item that you were speaking of? If I may approach the witness with what's been marked as QP for identification.
You may.
If you would take a look at the packaging associated with that item and tell me if it's something that you believe you've had contact with in the past.
Yes, it is.
What is it?
This is the sheet of heart-shaped stickers cut in half that was previously shown in photographs.
Were those collected by you, placed in that envelope and sealed?
Yes, they were.
Your Honor, at this point, I would seek to introduce QP for identification into evidence.
What says the defense?
Same motions and objections, Judge.
Noting previous motions and previous objections, they will be received in evidence over the defense objections and be given what number, Madam Clerk?
If I may have QY for identification. Can you see QY?
Yes, I do.
Do you recognize that as an item collected from the bedroom of Caylee Marie Anthony?
Yes, I do.
Does that photograph fairly and accurately depict the item collected?
Yes, it does.
Your Honor, at this point, I would seek to introduce QY for identification into evidence.
What says the defense?
Same motions and objections, Judge.
Noted same motions and objections. Objection would be overruled. Be received in evidence. The state's numbered.
311.
Permission to publish.
You may publish.
And if I may approach the witness with QO for identification.
You may.
If you would take a look at the packaging associated with that item and tell me if you believe that is something that you've had contact with in the past.
Yes, it is.
What is the item in QO for identification?
This is a sheet of metallic red heart-shaped stickers with 3 stickers remaining on the sheet.
If you look at QY, which has been introduced as 311 in evidence that is still on your screen, can you circle the item that is contained in QO? Your Honor, at this point, I would seek to introduce QO for identification into evidence as the state's next numbered exhibit.
What says the defense?
Same motions and objections.
Noted in previous motions, noted in objections, objections and motion. Objection will be overruled. It will be received in evidence. The state's numbered.
312.
Thank you, Ms. Burrows. Your Honor, I have no other questions of the witness.
Cross-examination.
Good afternoon, Ms. Burrows.
Afternoon.
The photograph on, can I see QV, please? Then I guess the next one. Sorry. That's it. 307. Your Honor, may I publish number 307 to both the witness and the jury?
You may.
Can you see,
Just a second.
I'm sorry. Can you see it, Ms. Burrows, the photo?
Yes, I can.
Can the ladies and gentlemen of the jury see it? Oh, now. Okay. Can you see the stamp on the right-hand corner of that item?
The postage stamp?
Yes, the postage stamp.
Yes,
Do you see 37 cents?
I do.
Okay. Do you know how long ago it's been since we've had 37-cent stamps?
I couldn't recall.
Okay. So obviously, this is a very old letter, is it not?
The date of the letter with a 37-cent stamp, but I couldn't say when that was actually mailed.
Right. I understand. There were items in this box that were significantly old.
I wouldn't feel comfortable making that statement.
Did you see scrap items, like baby shower items?
Yes, I did.
Okay. And did you see other items for a scrapbook
In that box or in the cabinet?
in the box?
No, I believe mostly baby shower items.
Okay. Can I have Q? May I publish item number 311 to both the jury and the witness, Your Honor?
You may.
Can you see that, Ms. Burrows?
Yes, I can.
Can the ladies and gentlemen of the jury see it as well? Okay. Now, there are also star stickers here.
Yes, there are.
There are a whole bunch of different stickers.
I see star stickers and the heart
You
stickers.
see Mickey Mouse stickers.
I don't recall if those are stickers or if they're just on a paper.
Okay. Do you see Pluto and other Disney characters, Minnie
Yes.
Mouse?
Yes, I do.
Okay. And do you see other scrapbook items in the room?
In
Or
the
did
room?
you see? Yes.
Yes.
Okay. This was a room that had a lot of children items in there, correct?
Would you define children items?
Scrapbooks for kids, things like that.
I don't recall seeing scrapbooks for children.
Did you see artwork of a child?
I don't recall.
Okay. You don't recall on the walls seeing different pieces of artwork that might have been done by a small child?
No, I don't. I recall seeing pictures, but no artwork.
Did you also search other areas of the home for stickers?
Yes.
Okay. And did you find any stickers in Caylee's room?
I don't recall if they were stickers, but there was a scrapbook page.
Okay. And did you take photographs of those of that scrapbook?
Yes, I did.
Okay. And they're not listed here or introduced into evidence?
No.
Okay. And what about in Cindy and George Anthony's room? Did you find anything in there? Or did you search there, I should ask first?
Yes.
Okay. And did you find any sticker type items in that room?
No stickers were recovered from the master bedroom, no.
Even ones that were actually placed on items? Or did you not consider those?
I honestly don't know what you're referring to.
I'm asking, did you find anything stuck to a piece of paper that would be considered a sticker in Cindy and George Anthony's room?
No.
Okay. Now, I'd like to show you Defense Exhibit W, which is a photograph of an item introduced into evidence in this case. May I approach the witness, Your Honor?
Show it to counsel. May I approach?
Yes. Since it's not introduced yet, I just want to ask you, do you understand that item to be something recovered off of Suburban Drive?
To my knowledge, yes.
Okay, and that is what you believe to be a sticker, correct?
I never held this object. I've seen photos of this object, so I wouldn't be comfortable determining whether or not it had an adhesive side.
Okay. Did you find anything remotely, well, did you find that item at the Anthony home?
This exact item?
Correct.
Because I have never actually held this item and I've only seen it in pictures, I wouldn't feel comfortable with that.
Okay. From what you see there, do you recognize what you see there from any item that you saw in the Anthony home?
Your Honor, I'm going to object. She's already indicated she's not comfortable giving her opinion about this.
She can answer the last question.
Can you repeat the question?
Sure. Did you find that item at the Anthony home?
Not to my knowledge, without actually holding the item.
Okay. We'll follow up with that later, but from what you can see, you didn't find that item at the house, right?
Again, I'm really not comfortable because I don't have measurements. I haven't held this item. I wouldn't be able to say in what size and if it was comparable to other items found in the house.
Okay. We understand. You have limited knowledge. You've just seen it in photographs.
Yes.
But from the items you've seen in photographs, you never saw that item at the Anthony home, correct?
Sustain.
Okay. How far away from an elementary school was Suburban Drive?
There was one in the vicinity.
Okay. How far would you say the vicinity?
I don't like to make estimates.
Just a very rough estimate. Was it next door, across the street?
There was
Down the
one
block?
not directly across the street, but it was on the opposite side of the street, some distance away.
Okay. Closer, about 100 yards? away?
Like I said, I don't feel comfortable making estimates on measurements.
Okay. Can we have that picture up? Okay. Would it be fair to say that there is an elementary school about,
What is the exhibit?
I'm sorry, Judge, BT 305?
You want it published to the jury?
Yes, sir. Can you see that, Ms. Burrows?
Yes.
I apologize. Can everyone see that? Okay. Would it be fair to say that approximately 30 yards from here is an elementary school?
Again, I'm not going to make an estimate as to distance, but there is an elementary school in the vicinity and it is not present in that picture.
Okay. But my question is it fair to say that it's about 30 yards from there? Or if you want to give it more, you can say 50, 100, however.
Because I've never been to that elementary school nor walked the distance from the crime scene, I'm not going to make an estimate of distance. I will say that it was in the vicinity.
Okay, so you can't help us any more than that.
Objection, Your Honor. This has been asked and answered 4 times.
Right here, ma'am, if you go further, that's a dead end, is it not?
If you continue all the way down, that road does dead end.
Okay. And there is nothing, no homes or anything else but an elementary school there, correct?
I did not travel to the dead end of the road to be able to say there weren't residences.
Okay. You were involved at the scene at Suburban Drive?
Yes,
Okay. And you were there for how many days?
roughly 9.
9 days. And you're aware that right here, it was cut off from the public, correct?
Yes, that's correct.
And you're also aware that the only traffic that was allowed through were school buses, were you not?
Yes, that's correct.
Okay. And that is because no other cars other than police cars were allowed through there, correct?
I believe families that were picking up children from that school were allowed down that road as well.
Okay. And no homes, no people, there was nothing else but a school there, right?
Again, I didn't travel that road to be able to answer that question.
Sustain.
Could you see anything other than a school there? A home, a barn, a shack, anything?
Objection, asked and answered.
I don't believe that. Is there anything to give you any indication other than there was a school there, madam?
No.
Okay. I have no further questions.
Any redirect? No redirect, Your Honor. Thank you, ma'am. You may be excused. Ms. Burrows, you're still in no. Mr. Baez, you may proceed, sir.
My apologies, Ms. Burrows. We happen to have the item that you looked at the photograph of. So that way I wanted you to see it. May I approach the witness, Your Honor?
You may. What is the item's number?
Yes, the item is states identification Caylee, which would be?
KB, it's not in yet. That's what she had offered. She had offered it, and there was an objection that you wanted to question the witness, so.
I'm withdrawing our objection so that I can ask her about the item.
Okay, and since there's no objection, that item will be received into evidence. The state's numbered
313.
Ms. Burrows, can you cut that open? I'll see if I can get you some of those.
Thank you.
Have you had an opportunity to look at the item?
Yes, I have.
And now you have it. It's not in a photograph, right?
Yes, correct.
Okay. Did you find that item at the Anthony home?
I did not find this exact item.
Okay. Did you find, that appears to be thick, does it not?
Yes,
Not a flat sticker?
correct.
Something that would be called, I guess, a bevel?
Yes, it's a raised surface.
Raised surface, yes. You didn't find anything like that at the Anthony home, did you?
No.
No further questions.
Any questions about the item? I have no questions about the item. May Ms. Burrows be excused?
When your granddaughter was found on December 11th of 2008, where were you?
We were at the airport in Los Angeles getting ready to board a plane to come home.
Okay. So you were not present then when the Orange County Sheriff's Office executed a search warrant at your home on that date?
No, ma'am, we were not.
Between the end of July of 2008 and December 11th, had you noticed whether or not any items had been removed or not at the house? Things that normally would have been there that belonged to Caylee?
From July, from
Any-
July what date?
Anytime in July of 2008 through December 11th?
July 3rd, I remember Caylee's teddy bear, Teddy, was missing.
All right. Did Caylee also have a blanket with Winnie the Pooh on it?
Yes.
Do you recall during that time frame noticing that the blanket was missing?
No, prior to that time frame, it was missing.
All right. When did you notice that the blanket was missing?
I hadn't seen it since the end of May. It had been a while since I had seen that blanket.
Now, we've seen some video of you and your husband, as well as your son and your daughter, taken in July of 2008. Is the hairstyle that you had in the videos taken when you visited at the jail the same hairstyle that you had had for a significant period of time?
What's a significant period of time?
6 months to a year.
6 months to a year, yes.
Okay. How about the length of your hair over a period of time, a year or more?
My hair grows very fast, so prior to that, my hair was longer.
How long?
Well, even in the last several years, my hair's been down here ever since Caylee's missing, so my hair grows very fast if I don't cut it. I have to cut it every 3 weeks.
And do you do that regularly?
Yes.
Okay. Do you keep it in the approximate style or length that it is currently?
Until recently, I just started wearing my hair like this again for the summer, but all through the winter months, I had grown it out again.
To how long?
It was probably past my shoulders around Christmas time.
Okay. The length of hair that we see in the July and August of 2008 videos, how long was it at that length?
Probably maybe a year and a half. Prior to that, I remember in 2006, my hair was long again. It was as long as yours is.
Okay. Now, has your hair been processed?
Yes.
In what way?
2001, I started, or actually 2002, I actually started putting hair color on. Prior to that, I just used highlights. I just would take strands of my hair and highlight it.
Ma'am, can you see two in evidence?
Yes.
Your Honor, may I publish to the jury?
You may.
Yes.
Okay. Do you have any idea when that photograph was taken?
I'm not sure the exact date, but I believe it was early in 2008, like the first couple months of 2008.
Do you see the length of Caylee's hair in that photograph?
Yes.
As we moved into the spring and early summer of 2008, before June 16th, had her hair grown?
Yes, but I would trim it every couple months. I would trim the ends off just to keep it healthy.
Okay. Aside from trimming her hair, would you subject the child's hair to any sort of processing?
Absolutely not.
Do you have knowledge, permission to unpublish?
You may.
Do you have knowledge as to what processing your daughter Casey had done on her hair in 2008 or earlier?
Casey started doing different things after Caylee was born. She never really did much with her hair as far as color treatment or anything, but after Caylee was born, she started cutting it shorter, and once in a while she'd either highlight it, and occasionally she'd dye it back to its natural color and then let it grow back out.
Okay. And what is your daughter Casey's natural hair color?
It's a brown.
If I may have QQ for identification. Ma'am, can you see QQ for identification?
Yes.
Okay. Do you recognize the individuals in that photograph?
Yes, it's Casey and Caylee.
Do you know when that photograph was taken, approximately?
I believe in the beginning of 2007.
Why do you think that?
Because Casey, her hair was short then, but it's because of Caylee. Caylee was a little bit chunkier, and you can definitely tell that she was a lot younger. Plus, I remember the clothing that she wore, and that her hair was a lot shorter and curlier, and her hair was a lot curlier when it was shorter when she was younger.
Your Honor, at this point, I would seek to introduce QQ for identification into evidence.
What says the defense?
No objections.
You received an evidence that states numbered.
314.
Permission to publish the item, Your Honor.
You may publish.
Ma'am, when would Caylee's second birthday have been?
August 9th of 2007.
Permission to unpublish?
You may.
If I may show the witness page 497 of her deposition.
Cunol, the brand I trust.
Ma'am, if I could direct your attention to lines 1 through 6.
I don't see it.
Object. I don't think there's a question pending, and she hasn't asked. This witness has not expressed any inability to recollect.
Heard it?
Your Honor, the witness has given a statement regarding when the picture was taken, and I would like to ask her about a prior statement she made regarding the same issue.
Overrule at this point.
Statement is inconsistent.
Well, she hadn't asked her a question yet. She's just showing her something.
Ms. Anthony, do you recall making a prior statement in deposition that the photograph was taken around Caylee's second birthday?
Basis of objection.
It's leading. And this is improper impeachment.
No impeachment yet. Objection overruled. You may continue.
Ma'am, do you recall making a statement that the photograph was taken around Caylee's second birthday?
Yes, I remember making that statement.
Her second birthday being in August of 2007?
Correct, but I don't think that we qualified, months prior or anything.
Okay. What hairstyle has your son Lee had in 2008 and before?
Lee usually keeps his hair short for the most part. We would shave his head not bald, but shave it down to just, the smallest cutting on the electric trimmers. And occasionally he would let it grow out, and about every 4 to 6 weeks we cut it, but it would never get more than like an inch long.
Do you know if your son Lee processed his hair in any way?
No, he never has.
Does your mother live in the area?
She lives in Mount Dora.
Do you have knowledge as to whether or not she was ever in the Sunfire?
I believe she was.
When?
We've had that car a long time, and I know that both Lee and Casey had driven the car up to visit my mom, and I know that they've taken her places when they were up there.
All right. Prior to June of 2008, when was the last time that you recall your mom was in the Sunfire?
I can't recall a specific date, but I know, that she had been in it before. I mean, George and I drove the car as well. So I know a lot of times we would trade out cars. The kids would trade the Sunfire for my 4Runner if they needed a bigger vehicle. So I would drive that car quite a bit, and I know I drove it up to Mount Dora as well.
All right. The question pending is, when was the last time your mother had been in the car prior to June of 2008?
I couldn't say for sure.
What kind of hair does she have?
She's had it different lengths, but never longer than her shoulder. In the last 10 years, it's always been shoulder length or a little shorter.
And what color is her hair?
She's got blonde and a little bit of brown and mostly gray and white.
Do you have knowledge as to whether or not any of your brothers have been in the Sunfire?
The only one that could have possibly is my oldest brother, but I don't think he has. But it's possible he could have ridden with either my son or Casey to the store or something.
Okay. And what sort of hairstyle would he have had at that point?
He keeps his hair very short, and his is blonde.
In 2008, were you aware of whether or not there was any duct tape in your home?
I recall black duct tape that we had, and I think we had blue at one point and possibly silver. I'm not sure. I'm not one to really use it. I know I did use the black when we had protesters because I used it to wrap the no trespassing signs.
Was any of the duct tape that was in your home kept anywhere other than the garage?
Not that I'm aware of.
Was any duct tape that was in your home used at a command center that was set up by the family?
Not ours. I know that the Kid Finders Network and George had purchased supplies for the command center, and I know that they did use duct tape to hold up some of the other children's posters and some of Caylee's posters at the command center. But I don't believe that came from our house.
All right. Do you recall making a statement that duct tape from your house was used at the command center? Have you ever made a statement?
Sustain, rephrase the question.
Have you ever made a statement that duct tape from your house was used at the command center?
If I did, I don't recall it. I could have.
All right. May I show the witness? Do you remember giving a deposition in this case back in July of 2009?
Yes, ma'am.
At that point, you were placed under oath and you answered questions for a period of time?
Yes, ma'am.
Okay, I was present as well as Mr. Baez.
Yes.
All right, if I may show the witness page 511. Actually, on this issue, if we could go to page 570, line 13.
I remember telling you about that episode, yes.
Okay. What do you recall saying about the duct tape that was in your house?
I remember George telling me about putting a piece of duct tape on the gas can. I never saw him do that, but I remember him telling me that when the gas can came back from the sheriff's department, that the little vent cover had been missing, and he placed a piece of tape over it.
All right. If I may refer you to 512, line 24. If we can get the question before that as well. Do you recall my asking when you explained about the use of the duct tape that was in the home on the gas can? Do you recall my asking where the roll of duct tape was currently at the time of the deposition in July of 2009?
I'd have to look at line 26 to be able to tell you that.
The complete answer, please.
Can I have yeah, sorry.
All right, can you give her the whole answer? It spans 2 pages. You might as well go through line 12 on page 513. Through line 12, please. Read that to yourself and tell me if that refreshes your recollection.
I recall that, but again, I recalled using duct tape at the command center, but did not know the origin of the duct tape if it came from our house. I think I was, I didn't specifically say who got the tape, but I know at some point that they did go and purchase duct tape.
Right. If I may have QS or QP. May I show the witness QT for identification?
You may.
Ma'am, do you recognize anything in QT for identification?
I recognize Caylee's sign, her poster from the Kid Finders Missing, the children's poster that they made for her.
Okay. Do you know where that poster was?
I'm not sure if it was on the inside of the tent in the middle part or on the one of the outside legs of the tent. That tent was moved so many times that I don't recall. And I wasn't there as often as George was, so I'm not sure if that was in the center post or on the outside post. On that picture, I can't tell.
And when you're referring to a tent, are you referring to a tent that was used at the command center?
Yes, in the beginning, we had those little pop-up tents that you purchase at the store. And then at one point, Kid Finders had a very large tent donated that had center poles. And that one we used at our last center on Goldenrod up by East Colonial. And I can't tell where this one's taken. I can't tell from this if this is one of those pop-up ones or the large tent.
Do you see an individual in the background?
I see someone, but I don't know who that is. at our last center on Goldenrod up by East Colonial, and I can't tell where this one's taken. I can't tell from this if this is one of those pop-up ones with a large tent.
Do you see an individual in the background?
I see someone, but I don't know who that is.
Right. If I may have QZ for identification, please.
Are you going to be introducing this photo?
At the appropriate time.
Okay. Just to let you know, we have no objections to the introduction of this photo at this time.
All right. Ma'am, do you recognize QZ as something that you've been shown before?
Yes.
Okay. And what do you recognize that to be?
And those are pictures of similar canvas items that we had purchased and had at the home.
All right. Do those pictures on that item accurately reflect items similar to what you had in your home at one time?
The top item, I can't tell the size. It's blurred, I can't see it. The bottom one, it looks like the one that we used in Caylee's room for her stuffed animals by her bed.
All right. Can you testify that you had items similar to both of those items pictured in your home at one time?
The bottom one with the measurements for sure. The top one I don't know because I can't tell the size. I'm not sure how big it is.
May I have QZ for identification? May I approach the witness, Your Honor?
You may.
I'm going to show you QZ and Exhibit 29 from your deposition. Tell me if those are identical.
Yes, they appear to be.
Can you see the size designation of the top item, number 2516?
I can on this one, not this one.
All right, on the one that was attached to your deposition as Exhibit 29, can you
This
read it
one?
on the,
The one with the holes in it?
yes,
Yes.
all right. After reviewing that, does that size that's indicated in that photograph comport with your memory as to the size of an item similar to that one that you had in your home at one time?
Yes, it's similar.
Okay. Your Honor, at this point, I would seek to introduce QZ for identification and evidence.
What says the defense?
No objections.
It will be received in evidence. It states numbered
315.
Permission to publish at this time?
You may publish.
All right, Mrs. Anthony, the item at the top of the screen, would you describe as cylindrical?
Yes, ma'am.
Did you have an item like that at your home in 2008 or 2007?
Yes, we did.
Okay, where was it kept?
At one point, we had it in one of the sheds. I remember storing some of Caylee's little plastic balls for a ball pit And then at some point, I got a laundry bag that had a zipper so the balls wouldn't fall out. And then I put that in the garage up over the laundry area on one of the shelves.
Is that the last place that you saw the item on the top, the cylindrical bag?
Yeah, I hadn't looked for that item or seen that item in a very long time since I used that, and it probably had been maybe 8 or 9 months prior to the summer of 2008.
Now, the item at the bottom of the exhibit, which is labeled 2213, did you have an item such as that at your home in
Yes,
2008?
Yes.
And where was the last place that you saw this item?
We had recently removed it from Caylee's bedroom. We had stored her stuffed animals in it, but then I found a hanging storage thing for stuffed animals where she could actually see them. It was like a tree. And at that time, we moved her stuffed animals to that and then put that in the garage area.
Do you recall, or did you ever make a statement that the last time that you saw item 2213 or the similar item that was in your home, the last time you saw it was in Caylee's bedroom?
Yes, I remember stating that because that's where at the time I thought I had remembered seeing it, but I recalled that the reason why I got the other thing was to put that away, and I had forgotten I had switched it out. Because there's a space between Caylee's bed and the wall where we had kept that. And after a while, when I was going into Caylee's room, I remembered certain things, and I remember taking that one out of there.
All right, so you agree that your memory in July of 2009 was that the last time that you saw this item, 2213, or the similar item in your home, it was in Caylee's bedroom?
I'm sorry, repeat it, I didn't follow you.
Do you recall making a different statement in
Yeah.
July of 2009 about the last place that you saw the item in your home that resembled 2213?
Yes, I recall making that statement that I last had seen it in Caylee's bedroom.
Do you recall, or did you make a statement that after the police had executed the search warrant, you believed that the item was no longer in Caylee's bedroom?
Again, that whole period of time, it was very difficult for me, and at that time, I thought it was still in her bedroom. But as I stated in a previous questioning with you, that my memory has gotten better
Over
of
time?
certain things. Yes, over time.
Okay. Permission to unpublish, Your Honor?
You may.
All right. If I may have 290 in evidence. May I publish, since this is already admitted into evidence, Your Honor?
You may.
The two bags that we were just referring to, the white bags that you kept stuffed animals in at one point, and then those plastic balls that you made reference to, were they stored, were either one of them stored in this location in the garage?
Yes.
Can you circle and let the members of the jury know where they were? Okay. What is that they are being stored inside of?
We would put anything that would collect dust, something that we couldn't wipe off, like fabric, or we had like the cat carrier and dog carriers up there. We would store the items in a trash bag.
Okay. If I may have 291, and permission to publish that one as well, Your Honor.
You may.
Ma'am, do you recognize the close-up of that portion of the garage in 291 in evidence?
Yes.
Okay. Is the type of container that you would have those white bags in consistent with the container shown, the black plastic bags in 291?
Yes, it would be in either one of them. I wouldn't know which one it would have been in.
After the execution of the search warrant on December 11th of 2008, did you see either one of those items again?
No.
If I may have 281 in evidence and permission to publish that as well.
You may.
Do you see the item that you were referring to that used to be kept in the cylindrical
Yes.
bag?
Yes.
Can you circle that and point it out for the jury? Okay, what is inside of that?
Little plastic balls that you'd find in a ball pit.
May I have a moment, Your Honor?
You may.
I show the witness 13 in evidence.
You may.
Mrs. Anthony, do you recognize 13 in evidence to be a photograph of your daughter and granddaughter?
Yes.
The shirt, and if we could zoom in on Caylee, please. Do you recognize the shirt that Caylee is wearing?
The first time I had ever seen that shirt was during my deposition.
Your Honor, may I publish?
You may.
Did you do the laundry at the home?
Yes. Most of the time. George and Casey did it once in a while too.
Would it be fair to say that you've never seen that shirt at your house?
I don't ever remember seeing that shirt.
And you never saw the picture of Caylee in the shirt until July of 2009?
No.
Thank you, Mrs. Anthony. I don't have any other questions of the witness, Your Honor.
Okay, be a good time to take our mid-afternoon recess. We'll be in recess to 3 o'clock. Members of the jury, please do not discuss this case among yourselves. And please remember all of my previous admonitions.
Yes, sir, we do.
Okay, Mr. Baez, you may proceed with your cross-examination.
Thank you, Your Honor. May it please the court. Good afternoon, Mrs. Anthony. I want to try and take things back into perspective, if I can. Your granddaughter Caylee was found on December 11th, 2008, correct?
Yes,
And on December 11th, 2008, the police executed a search warrant of your home.
yes, I found out after that, yes.
And you weren't home.
No,
In fact, you didn't go home for a couple days later.
we went home the next day to gather our dogs.
But it was a couple days before you actually went back to the house, correct?
Yes,
Okay. And after that, you were home for a few days and you got to see what the police had done in your absence.
yes,
And then on December 20th, the police came back and executed a second search warrant of your home.
yes.
And during that second execution of the search warrant, well, actually, let me backtrack for a moment. When you got home, you saw a copy of the search warrant there and the items that they had confiscated from your home, correct?
No,
Okay. Did they give them to your attorney at the time?
I'm not sure at what point we got them. It took us a while to get the copy of the items.
Okay. And the 20th, when the police arrived at your home, it was a difficult time for you
Absolutely,
and the rest of your family as well.
yes,
And there was somewhat of a confrontation when the police arrived. Isn't that correct?
Relevancy?
It relates to the items listed. It relates to the issues raised during direct examination. I can tie it in fairly quickly, Judge.
Overall, for now.
Fair to say it was somewhat of a confrontational moment.
yes,
Okay. And in fact, George had to be taken to the back area, correct?
Objection, irrelevant, outside the scope of direct.
I'm going to tie it in within a matter of 3 questions, Judge.
Sustain this to the last question. Next question.
Mrs. Anthony, at that point, did you tell law enforcement that that's when you told them there was a missing blanket?
I don't know when I told him about a blanket.
Okay. Are you aware that that's a statement you made to them at that time on December 20th?
Not until you're telling me right now.
Okay. Are you aware that on the search warrant of December 11th, there was mentioning on the actual warrant for Winnie the Pooh blankets?
Your Honor, I'm going to object. He's asking questions based on the items not in evidence.
These are direct lines of questionings by Ms. Drain Burdick.
Approach. You may proceed.
Thank you, sir. Mrs. Anthony, when you came back home a couple days after December 11th of 2008, your house was a mess.
Yes,
And the police had basically turned the house upside down.
yes,
And they didn't put anything back.
no,
And they took items, did they not?
yes,
And included in the items was Caylee's bedding set, correct?
yes, at some point her bedding set was taken.
So you were aware when you came back that they were interested in her bedding material?
I wasn't sure what they were interested in. They opened just about every drawer and looked under every little thing.
Okay. Now, can I have page 570? The, Ms. Drain Burdick had, may I publish this to the witness, Judge? States it was 570.
That's deposition.
Yes, this is testimony that she was shown during her direct examination. I want to ask her some questions about it.
Go ahead.
Okay. Can you see that, Mrs. Anthony?
Yes.
Okay. On line, I'd like for you to read for a moment lines 10 through 15.
Yes.
And during direct examination, when you were asked along this lines of questioning, what exactly was the question asked to you during this?
I'm going to object. It's the lawyer who has to ask the question. This is improper. There's no impeachment going on with this question and answer.
I'm not impeaching her. I'm asking her questions that she was asked during direct examination. She was shown this item and discussed it.
The page that he's referring to is hearsay, and we would object on that basis
The page
from the deposition.
hearsay in terms of who was the person who was being questioned.
Right? It's an out-of-court statement. If he wants to ask her it independent of it rather than reading from a hearsay document, that's one thing, but it would have to be impeaching information.
He can ask the form of the question and the leading question, so you can read the question and give her an answer. You're on cross-examination. Go ahead.
10 through 15. Mrs. Anthony, were you asked by Ms. Drain Burdick if Casey removed any duct tape from the house when she was out of jail for the period of time, the 2 periods of time? Were you asked that question?
I don't remember, but if it's in my deposition, then I must have been asked that question.
Does that refresh your recollection that you were asked that question? Do you see that there?
No, I don't remember talking about, I don't remember them asking me if Casey removed any duct tape, but if it's in there, then I had a 2-day deposition, so I don't remember every single thing that she asked me.
I understand, it's a couple years later, but did you respond, as far as I remember, no, because I think we only had 1 roll of duct tape.
Proper impeachment, the witness said she did not remember if he wanted to try to refresh her recollection, but at this juncture, she says she does not remember the question. So I object to counsel reading it as improper impeachment.
Mr. Baez?
This testimony was elicited by, we're in a little bit of a unique situation because Ms. Drain Burdick had questioned her
Go
about
ahead and
this.
establish the predicate for past recollection recorded.
Sure. If I can have just a moment, Judge. May I approach the witness, Your Honor?
You may.
Do you recall giving a deposition in this case, ma'am?
Yes.
And if you could look at the front, the first page to give the date, and the first, hold on, yeah, the very front.
July 29th, 2009.
Okay. And were you placed under oath at that time?
Yes.
Okay. And can you read that 10 through 15, lines 10 through 15?
10 is question, okay, did Casey remove any duct tape from the house when she was out of jail?
Wait, slow down. She can't hear you, Miss.
Okay.
And you take your time.
Question was, okay, did Casey remove any duct tape from the house when she was out of jail for that period of time, the 2 periods of time?
And can you give the answer?
As far as I remember, no, because I think we only had 1 roll of duct tape and George was using that.
So it was your understanding when you took the deposition that you only had 1 roll of duct tape, correct?
Yes, during that time period when Casey was out of jail, we had a black roll of duct tape, and we were using it all the time to repair our signs that the protesters would knock down in front of our house. So yes.
And your understanding was that the only one using that one roll of duct tape was George?
Well, I would be using it too for those signs.
The answer you gave in the deposition was that the only person using that one roll of duct tape was George Anthony, correct?
Probably. Again, it's the context of the questioning.
I understand, ma'am. Now, I'd like to talk about the Good. May I show the witness, Your Honor, states evidence 314 and publish for the jury as well.
You may.
Can you see that photograph, Mrs. Anthony?
Yes.
Can the ladies and gentlemen of the jury see the photograph? Okay. Prior to me getting into the photograph, Mrs. Anthony, I'd like to ask you, how long have you owned the Pontiac Sunfire?
I think since 2000.
Okay. So you had owned it for 8 years in total, correct? Prior to it being confiscated in this case.
Yes.
And your hair length has changed numerous times throughout that time period.
Yes.
And so has that of Casey.
Yes.
And so has that of Caylee.
Yes.
And I know we touched on your mother as well, having access to the car, but I presume her hair has changed as well.
Her length hasn't ever gone past her shoulders.
Okay. And how many inches would you say the length of her hair was?
The longest, maybe just right to here.
Okay. Can you give us a guesstimate?
5 inches.
Okay. And Lee's hair has also varied in length, correct?
Yes, his hair is usually very short.
Okay. Now, turning your focus to the photograph, this photograph was taken in early 2007, correct?
Yes.
And Caylee would have been, at that time, younger than 2 years old?
Yes.
Okay. Approximately 15 months, would you say?
I would say maybe 18 months.
Okay. And the shorts are 24,
Correct.
correct? And in June 16th of 2008, a year and 3 months later, Caylee has grown significantly, has she not?
Yes.
In fact, Caylee no longer fit into these shorts, did she?
I don't believe so.
Okay. She had outgrown these shorts.
She was in 3Ts.
Okay. And these are 24 months, correct?
I think so.
So would it be a fair statement to make that whoever put these shorts on her were not familiar with her size?
Your Honor, I'm going to object. He's asking the witness to speculate.
Sustain.
But as you testified under direct examination, ma'am, that, oh, never mind, I'll withdraw the question. Thank you, Mrs. Anthony.
Redirect. Okay, thank you, Mrs. Anthony. You may stand down. Okay, members of the jury, you had asked earlier to have an opportunity to see Exhibit 313. We can publish it via the document camera, and we can also pass it around for you to look at. Would you like one or both of those methods? Okay, so we will publish it on the document camera. Please read the writing contained on the exhibit so the jury would understand when this item was originally taken into custody, how the exhibit currently was brought into custody.
Exhibit 313 is identified as a piece of cardboard matting with pink raised heart-shaped material attached.
You will also notice now that it has separated.